Tulek 1, Oklahoma Cherokee children were disappearing. At weekly staff meetings, Todd Hembry, the Attorney General of the Cherokee Nation, kept hearing about babies in opioid withdrawal and youngsters with addicted parents, all being removed from families. The crush on the foster care system was so great that the unthinkable had become inevitable. 70% of the Cherokee foster children in Oklahoma had to be placed in the homes of non-Indians. "We have addicted mothers and fathers who don't give a damn about what their children will carry on," said Mr. Hembry, a descendant of a revered 19th-century chief. "They can't care for themselves, much less anything else. We are losing a generation of our continuity." Across the country, tens of thousands of people are dying from abuse of prescription opioids. Here in the capital of the Cherokee Nation, the epidemic is exacting an additional, deeply painful price. The tribe's carefully tended heritage, traditions, and memories, handed down through generations, are at risk, with so many families now being ruptured by drugs. That fear is driving an unusual legal battle. Like authorities in dozens of cities, counties, and states, including Ohio, New Jersey and Oklahoma itself, Mr. Hembry has sued big opioid distributors. Attorneys general from 41 states recently joined forces to investigate similar options. But instead of going to state court, Mr. Hembry filed his case in the Cherokee Nation's tribal court. The Cherokee suit argues that the pharmacy chains Walmart, Walgreens, and CVS Health, as well as the giant drug distributors McKesson, Cardinal Health, and AmerisourceBergen, flouted federal drug monitoring laws and allowed prescription opioids to pour into the Cherokee Territory at some of the highest rates in the country. Such neglect, Mr. Hembry claims, amounts to exploitation of a people. The companies have responded by asking a federal judge to deny the tribe's authority to bring the case. They argue that a tribe cannot sue them in tribal court, much less enforce federal drug laws. They have questioned whether a Cherokee reservation even legally exists. "We believe this lawsuit has no merit," a CVS spokesman said. Both sides have mobilized battalions of prominent lawyers. Lindsey G. Robertson, an authority on Native American law at the University of Oklahoma College of Law who is not involved in the lawsuit, believes that the case will indeed go to tribal court. He pointed to a 1985 Supreme Court ruling, which said that, barring extraordinary circumstances, a federal court should not rule on tribal court jurisdictional questions before they have been fully litigated in tribal court. A ruling is expected soon and, regardless of the outcome, will almost certainly be appealed. For the Cherokee, the case is fundamentally about defending their identity and survival as a tribe. "I believe these companies target populations," said Mr. Hembry, whose office displays include a feathered spear and a dish of bundled sage to burn for traditional blessings. "They know Native Americans have higher rates of addiction.